At the start of the session, you must have noticed that there was a technical glitch when Vaibhav started discussing his paper. And let me tell you that if it is a GST conference, that technical glitch is not a bug, it's a feature. That is expected to happen. So friends, even in one of the opening remarks, and I think multiple speakers have talked about the fact that the honeymoon period is over for GST. And let me tell you that if you are an indirect tax consultant, then in GST, the courtship starts after honeymoon period. Because you are supposed to visit the courts more often than not after the 5 years era ends. So when we talk about this interesting judgment, friends, the only underlying issue which is there in the judgment is basically who is the real employer. This judgment talks about service tax law. Naturally, all of you will say, what is the context, why we are discussing a service tax judgment here? But as all of us are aware that in GST there is something called as matching, we all the time do. So matching is not only with respect to the invoices, but also with respect to judgments. So you are supposed to match a service tax judgment with GST and a GST judgment such as Mohit Minerals with service tax also. Because with respect to service tax, you would be surprised to know that ocean freight issue is yet to be decided by the apex court. So that's the interesting part. When you look at this judgment, the critical or key important aspects are, this is a Supreme Court judgment delivered by the larger bench in the context of service tax law, running into more than 30 pages. There are more than 68 paras, and the Supreme Court has taken into consideration more than 28 cases running right from 1957 to 2021. And the facts are, I would say, pretty simple. To put it across, there is a non-resident entity, Northern Operating Systems, UK, which is located outside India, and they have entered into a deputation agreement with their subsidiary company which is located in India, that is NOS India. In terms of that secondment agreement, the persons, that is the people who are working with UK entity, they are sent to India. So they are working as second in India. And when this person is working under the supervision and control of the Indian entity, naturally at the month end, he is supposed to receive certain salary. Now these salaries are being paid by the UK entity directly into the secondee's account, that too in UK, and this amount is finally then repaid back. Correct? This amount is repaid back by the Indian entity by way of remittances. Now when you look at this kind of fact matrix, then the question arises, who is the real employer? Is it the NOS UK who is the real employer? Because if you say they are the real employer, then service tax under reverse charge would be payable because the Indian entity is making certain remittances outside India. And if you say that the Indian entity is the employer, then naturally service tax liability will not arise. To make it more simpler, I would say this movie all of you would have seen. So in this movie there is Sivagami, there is Kattappa, and there is Amarendra Bahubali. So Mr. Kattappa is person on deputation. Now the million-dollar question, because literally speaking, the amount of tax involved was more than 25 crore rupees in this case. Correct? So look at the fate of the indirect tax consultant who had suggested them not to pay. So this judgment has not only upset numerous judicial precedences, but also the indirect tax consultant who were working on this case. And also similarly many other people. Now when we look at the legal provisions are threefold, because you are supposed to understand the positive list regime and negative list regime. If you are a fresh or newcomer, please note that there was something known as service tax law, which most of you would be aware. Now what was this service tax law or what was this legislation? I will just briefly share with you an anecdote. We will understand what this legislation was. In Goa, there were 4 brothers, and these 4 brothers were mafia, ekdam gunda types ke, barabar hai. The eldest one died. Now all of you know that when somebody dies, you are supposed to say something good about him before the last procession takes place. But because that person was so, like say, he was all the time gundagiri karta tha, drug ke kaam karta tha vagera, so nobody was coming out on the stage and speaking anything about that person. So then one senior person was requested कि कुछ तो बोलो sir. तो तीनों भाई गए कि sir कुछ तो बोलो ना, हमारा भाई चला गया है. So then this senior fellow, he says कि ये पर्सन ड्रगिस्ट था, इसने काफ़ी सारा चोरी चकारी का काम किया है, सब कुछ गलत किया, लेकिन एक मैं अच्छी चीज़ इसकी बता सकता हूँ, ये है कि जो चला गया ना, वो जो 3 जिंदा भाई है उससे अच्छा था. बराबर है. And that's what service tax law is for all of you. बिकॉज जो 3 जिंदा भाई है, CGST, HGST एंड IGST, उनके कंटेक्स्ट में service tax अच्छा ही है. Now, when you talk about that service tax law, that particular regime, and this particular issue that is secondment, please note that in this particular secondment related issue, right now we are in 22, that is 16 years, and this is 16th RRC also, correct? So in 16 years, almost all the judgments, and you can see there are more than 21 judgments on the screen. In 16 years, right from 2006 to 2022, all the judgments were in favor of the taxpayers. They were in favor of the taxpayer. There was only one judgment, that is INA bearing, which was against the taxpayer. And how many judgments were in favor? Who was in favor? That Commissioner Appeal का जो judgment था वो favorable था. 2 High Court के judgment favorable थे कि tax payable नहीं है secondment के case में, and Chennai Tribunal, Delhi, Mumbai, Bangalore, Ahmedabad, almost all the tribunal except one particular case. So now in this kind of a scenario, normally every indirect tax consultant whom you are going to approach, he will say tax is not payable, you don't pay on reverse charge, correct? But obviously, if you are attending RRC and any one of you happens to be a taxpayer, let me tell you that whenever you are hearing any view from an indirect tax consultant, you should not take it with a pinch of salt. You should take it with a container of salt. That is how you should apply your judgment, correct? Because 20 cases in favor, only one against. But finally what happened? Yes, the Supreme Court turned this case in favor of the revenue. And this is again a classic case. This is as good as a fiat judgment for service tax legislation. As good as a fiat judgment. And I would say it goes beyond fiat judgment also. And why? Let us understand. Today is Saturday evening. All of you are supposed to visit this place called as Tito. At least as far as I am concerned, I am running 40s. For me, this is the topmost place. I don't know about you. I think young guys would be having more such kind of new names. But Tito is the most famous place. And when you try to understand the judgment of the Supreme Court, these 4 words you just remember. TITO, totality, irrelevant, then test, and overall. These 4 words will summarize the entire judgment. So first, totality or overall basis. What the Supreme Court is saying at various paras, and this word overall and totality, the Supreme Court has used more than 20 times. So, more than 10 times. The Supreme Court says that whenever you are trying to analyze facts of any particular case and when you are trying to give a judgment, you are supposed to do an overall reading and then come to a conclusion. At one interesting paragraph, the Supreme Court says that our task is not to unravel the relationship between the two parties, and exactly after a couple of paras, the Supreme Court is doing the same thing. They are trying to unearth the exact essence of that particular transaction and identify what is and trying to discern the true nature of that particular transaction. Then the Supreme Court says that we are supposed to, Honorable Supreme Court says that we have to look at the substance over form. Now friends, when you look at these kind of terminology, please note these are qualitative terms. These are not quantitative terms. They are saying substance over form, then they are saying overall reading, then they are saying that on a totality basis. All these are qualitative terms. Now how they will be applied by the tax authorities in days to come in the GST era is something we need to see and observe. Now, when we are saying that the Supreme Court is saying that we are going to take into consideration all the facts together, and we will ignore that particular agreement because there is an agreement, deputation agreement, through which these people are deployed as an employee. Even the salary, TDS is deducted, correct? Even the professional, all labor laws are complied with. So all those facts are ignored. Why? Because the Supreme Court says we are supposed to see on an overall basis. And when we are looking at the overall scheme of things, this transaction, this agreement we can ignore. So this is, I would say, a very serious observation because it is as good as lifting the corporate well, which typically a Supreme Court is not supposed to do, typically unless and until it's a fraudulent case. But even in a genuine regular case also, you can see that this is a kind of law we can see which is evolving. And if this is the start of these kind of judgments are being taken up, then certainly in days to come, we are going to, as an indirect tax consultant, it is going to be ease of doing business. I'm not sure about the taxpayers, but certainly for the indirect tax consultants. So the Supreme Court, after this observation that you are supposed to see it on an overall basis and then substance you have to see rather than the form, then it says that there are certain highly skilled employees which are there with the UK entities. And these people are supposed to be deputed or handed over to the Indian entity. And this activity in itself can be construed as a business of this northern operating systems, UK, because they are giving these highly skilled employees to the Indian entity. Because one of the contention with the taxpayer had taken was there is, how you can say it's a manpower supply, because this entity, that is UK entity, is not engaged in the business of supplying manpower. But the Supreme Court, looking at various, obviously the clauses of the agreement, looking at overall scheme of thing, and they also mentioned that the vital fact is that the nature of overseas group companies business appears to be securing contract which can be performed by highly trained and skilled personnel. And that's the reason they say that these skilled persons are then loaned to the Indian entity or any other entity, and this itself is a case of supply of manpower, and automatically the tax liability will trigger. The Supreme Court also talks about one of the most important tests, that is test of control and supervision. If you are married, you know control and supervision, correct? So the same test, you are all the time under supervision, you are all the time under control, correct? So the Supreme Court says, yes, the Indian employee is all the time under control and supervision of the Indian entity, that person who is working, deputy. But still the fact remains that the salary of this person is being processed by the entity who is outside India. The social security benefits, they are taking care. Even the terms of the contract, correct? They have been determined, dictated by the non-resident entity. So all these facts the Supreme Court has taken into consideration. And finally the Supreme Court says that these people, the deputed person, would be going back to the non-resident entity again. So the Supreme Court said, look at the start of the transaction. Start is the salary. What should be the salary of that person? What should be the terms? That is being dictated or determined by the non-resident entity. Salary is continuously processed by them. Social security benefit is continuously processed by them. And finally, after deputation period, this person is going back to the non-resident entity. If you look at all these things cumulatively, then the Supreme Court has come to a conclusion that this is as good as a supply of manpower, because that person is working, although on a day-to-day basis under the Indian entity, but still the activity will qualify as a supply of manpower by the non-resident entity to the Indian entity. Then one of the contention of the taxpayer was there is no consideration, because what we are paying is as good as the reimbursement of the salary payments. So reimbursements are not supposed to be liable to taxes. So that's what contention the taxpayer had taken. But then the Supreme Court said that the mere payment in the form of remittances can be one of the method of reckoning if there is a consideration. And then it goes on to say, and this is very interesting, and I would say again, this is as good as a fiat kind of a feeling, because in fiat, I think all of you will be aware, in excise regime, the Supreme Court said that if you are trying to sell your cars below a particular price just to penetrate the market, then it is also additional consideration. So in a similar context, this para appears. It says the other way of looking at the arrangement is that economic benefit is derived by the assessee, which also secures specific jobs or assignment from the overseas group companies, and the quid pro quo is implicit. Now, as an Indian entity, if I am receiving certain work from the non-resident entity, correct? So the Supreme Court says that the quid pro quo is implicit. Now, please note, in this case, it is not receipt. The consideration should be paid by me, no? So there is a contradiction here. The Supreme Court is observing one thing and saying another thing. So again, as a GST consultant, we are supposed to match what the Supreme Court is saying and what it is observing, which is actually contradictory. And at many places it contradicts. But yes, being an honorable Supreme Court and that being the law of the land right now, as was observed by Ishan also, we are supposed to follow the judgment. I would say the final death on the nail kind of a thing, the final point which we need to understand from this particular judgment is that this judgment says that revenue neutrality is an irrelevant argument. And I think that's something which we need to worry about a lot now, because this was one of the argument or contention which was almost taken in all the cases whenever we were talking about reverse charge cases. But now the Supreme Court has said that it's an irrelevant detail. Naturally, if it is an irrelevant detail, that means very unlikely that we will be in a position to take this kind of argument before the tax authorities, particularly in the case of GST also. Friends, as I mentioned, numerous judgments, more than 28 judgments the Supreme Court has referred. You can see the 6 judgments which repeatedly being quoted in this particular case. Almost all the judgments related to either the Factories Act, Compensation Act and all. So these judgments which have been relied on by the Supreme Court are not perimetria, the indirect taxes. Even there are two income tax related judgments also. If all of you would be aware about the Daiichi Karkaria judgment at paragraph 21, Supreme Court says that even the income tax related judgments are not relevant for indirect taxes. So why then the various legal provisions, how the legal provisions and other laws or the judgments given in the context of other laws, how they can be relevant is a big question mark. So the way forward, I would say, when we talk about reverse charge, I remember way back in 2016-17 when we were discussing with one of our clients, which is a large IT company from Pune, there was a liability of 45 crore under reverse charge mechanism for that particular company. We fought with the tax authorities for around a year, and we were successfully, represented that case and brought down the demand from 45 crore to 16 crore by telling them that the other period is time barred. And finally, we received a show cause notice in the month of March 2017 for 16 crore. We had a couple of rounds of discussion with that company, and we suggested them to pay this liability upfront, 16 crore. But their legal consultant, they objected. So we had a meeting with them, and one of the argument or contention which this legal consultant put across, he was a legal consultant for the company, he said, why to pay the 16 crore under reverse charge when we can litigate? And we had we had countered that, we had said, why to litigate when we can pay? And the company finally paid in the month of April 2017, before GST took the credit, claimed the refund, and matter was over, then and there only. So I think similar kind of approach you also can have. Friends, when you are dealing in GST, please note, you need to cover two things, fact and law. And there is only one door, correct? And that's the task we are supposed to do. So with this, we are through with our session. I hope you found it interesting. Yes, thank you all, your wonderful audience. And I must mention, because all my Gurujis are sitting here, Sunil sir, under whose able guidance I was able to learn indirect taxes when I was working with Sunil sir for a year. Then A.R. Krishnan sir, I think he is not there, Parin sir, Naresh bhai, Vaiti Saran sir, Raghuraman sir, Naveen Kumar sir, pehli baar hi mila, sorry. So, Naveen Kumar sir, so many legends are there, and through them only, whatever today, if you like the session, I think all the credit, and not the GST credit, because that doesn't appear. All the real credit goes to all these champions and legends, because they have been very kind enough for a person like me. When, I don't know how many of you know, I failed in indirect taxes in 2004. I never ever failed in my life, in any one topic. I only failed in indirect tax, not something to clap about now. Then second important thing, in last decade, just 12, 13 years before, I was asked to quit a company, a consulting organization, because I was not knowing indirect taxes. And it's a reality. I was given a pink slip, very good word, they use pink slip. Nothing pink about it, but I was asked to resign in that firm. And then I joined Sunil sir, he was very kind enough. I learned from him, and obviously all the legends, S.S. Gupta sir, A.R. Krishnan sir, Naresh bhai, सबके sessions सुन के learn किया बहुत सारा, and wherever today I am, all the credit, 100% goes to them only. So thank you all, thanks. And
Pritam,
thank you, I would say.
Pritam,
Thank you, Pritam.
one more learning I want to give you, as far as way forward is concerned.
हाँ sir.
Now when client approaches to us, don't ask his facts of the case, brief of the case. You just ask just his kundalini, astrology. कि भाई क्या होने वाला है? Then you give the advice. I think.
सर, कुंडली पे मैं शादी के बाद बिलीव नहीं करता सर, बिकॉज मेरे जो महाराज है उन्होंने 36 गुण मैच करके दिए थे, 36 गुण.
मेरा और तेरा स्टोरी एक ही है.
सेम है. Sir, so thank you.
Are there any technical questions to him other than the... Thank you, Pritam. Thank you very much for your presentation with added humor to that too. Thank you.